Welcome to U.S. Immigration TV. Now recently there was a Ninth Circuit Court of Appeal opinion which I believe is great news and offers new hope for people who are required to file a waiver demonstrating extreme hardship on certain close relatives. Now if you or someone you know is required to file what is called a hardship waiver, make sure to watch this video until the end, and of course make sure to like, share, and subscribe to this channel. Now, by way of background, in certain cases, a person may be ineligible for a visa or they are considered inadmissible based on various immigration violations, and they must file a waiver. Now, this can include a fraud waiver, for example, if the person committed fraud or misrepresentation, such as entering the U.S. under an assumed name or a different name on their passport, or they have submitted bogus, altered, or forged documents. A hardship waiver is also required if a person is subject to the 3 or the 10-year bar, for having overstayed for more than 6 months or a year, or if they are seeking a provisional waiver. Now, if a hardship waiver is required, the person must demonstrate that they have a spouse or a parent who is a U.S. citizen or lawful permanent resident, a green card holder, and they are called qualifying relatives, and the qualifying relative would suffer extreme hardship if the waiver is not granted. Well, the USCIS has a policy manual, and it has devoted an entire chapter on extreme hardship, such as what constitutes extreme hardship, the type of proof that is necessary, and the type of documents that are needed. Okay, now here is where that case comes into play. One of the basic factors is demonstrating the extreme hardship a qualifying relative would suffer if they are required to relocate to their family member's home country. In other words, the stress, the trauma, the anxiety a U.S. citizen would have to endure if they were to uproot themselves from the U.S., leaving behind their job, their other family members, their health care, and move back to their relative's home country. Now, what makes this Ninth Circuit decision so important is that the court said it would basically be a violation of the qualifying relative's constitutional rights if they are required to relocate. Therefore, I would argue that not only does relocation result in the qualifying relative suffering from extreme hardship, it also violates his or her due process rights under the U.S. Constitution, and therefore USCIS requiring a qualifying relative to relocate is basically unconstitutional. Now, that court case dealt with an entirely different issue. I want to be clear about that. It dealt with the doctrine of consular non-reviewability, which I will discuss in a different video. But the case had very important and helpful language in connection with people being required to file a hardship waiver. The court noted, first off, that marriage is a constitutionally protected right or liberty interest. As the court said, and I quote, "Freedom of personal choice in matters of marriage and family is one of the liberties protected by the Due Process Clause." Well, the court further noted that not only does a U.S. citizen's spouse have a constitutionally protected right in their marriage, but they also have a constitutionally protected right to live in their country of citizenship. Both rights. As the court said, in addition to having a fundamental liberty interest in their marriage, U.S. citizens also possess a liberty interest in residing in their country of citizenship. Now, the court further pointed out that it is wrong to require a U.S. citizen to choose between living with their spouse in a foreign country or living alone in their country of citizenship, which is the United States. As the court said, the cumulative effect of such a denial of a visa is a direct restraint on the citizen's liberty interest protected under the Due Process Clause because it conditions the enjoyment of one fundamental right, which is marriage, on the sacrifice of another, which is residing in one's country of citizenship. The denial of an immigrant visa to the spouse of a U.S. citizen deprives that citizen of the ability to enjoy the benefits of her marriage and to live in her country of citizenship. In other words, what this case means is that relocation or forcing a U.S. citizen spouse to prove hardship based on relocation, they shouldn't have to, because forcing them to relocate violates their constitutional rights, period. And that should be enough that the waiver should be approved. And in fact, that's what I would be arguing for my clients. That's what this case means. Now, this is something I believe is really worth fighting for on behalf of clients. Now, I hope you have found this video informative, and I will continue posting videos which I think and I hope would be helpful to you or to someone you know. Therefore, make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.